So hi and welcome. Would you please state your name and profession?
Hi, yes, I'm Antoine Babinet, and I'm a member of the DMA task force in DigiComp, so in the European Commission.
And why did you specialize in competition law?
Well, I actually did a dual degree in law and economics, and I actually really liked both subjects. So I basically didn't want to drop any of the two. So I was super happy when I heard of competition law, because it was exactly the way to practice law while using economics in the substance of the arguments. So that's how I ended up doing competition law.
Excellent. So I let my students know that as well. In your experience as an antitrust enforcer, how will the enforcement of the Digital Markets Act be different from antitrust enforcement?
Well, I think the big difference will be that we will basically be moving directly to finding solutions. Whereas, before there was a lot of time spent on actually discussing whether a conduct is illegal. Now it's made much easier in the DMA, because the DMA tells you exactly what is prohibited, what is illegal. So, I mean, that allows to move basically directly to intervening and really coming up with something that will have a concrete impact. So I think that's really the idea.
Once we get past the gatekeeper position, right, which we're discussing today.
Exactly.
I know the next one is a tricky question, but what is your favorite competition law case at the moment and why?
It's tricky. It's actually very geeky as well, but it's okay, because that's what I am. So no, I think my background is really in merger controls. So I mean, one that I've followed super carefully lately is the Illumina Grail saga, because it's not even a case. I mean, at this level, it's becomes a saga. I mean, there were constant developments. I think the Commission also really pushed the boundaries in terms of procedure. And they really went for very unusual procedures. I mean, the new Article 20 to basically certain jurisdictions on transaction, and also the interim measures when Illumina basically implemented the transaction while the review was still ongoing. So I think all of this was pretty groundbreaking and exciting. Yeah.
Good. So coming back to the Digital Markets Act, what is the one thing that every competition lawyer should know about the interaction of the Digital Markets Act on the one side and Article 102 of the treaty on the other side?
Well, there I think they are just truly complementary, and this means that there will really still be a role for Article 102 proceedings in digital after the DMA is fully active. And for example, I mean, I could see that 102 proceedings will apply to new type of conducts that have not made their way in the list of the DMA. Also, the DMA scope is limited to I mean, limited. It's still a wide scope, but to core platform services. So there are digital services that are not within the scope, and I mean, this is also an area where if there is a dominant undertaking, that there could be 102 proceedings.
So companies beware, you'll have two things to look out for.
It's just a broader toolbox. So, it's even more options for enforcer.
Absolutely. So thank you so much. And we're looking forward to speaking to you in a moment.
Me too.